Getting pulled over for DUI is one of those moments that instantly spikes your heart rate. Just the moment you see those red and blue lights flashing. So you pull over, your hands start to shake a little bit, and right then, before you've even done any breath test, any field sobriety test, the officer, he walks up and he starts talking. That's when the real test begins. Because what you say next could cost you your driver's license, it could land you in jail, and is really the difference between a routine traffic stop and a DUI conviction on your record. Most people don't realize this. Officers are trained to ask you very specific questions that they sound casual, but they're designed to get you to incriminate yourself. I'm Derek Martin, a DUI attorney here in Chicago, and in this video, we're going to talk about 5 of the most common trick questions that an officer will ask you during a DUI investigation. And in this video, we're going to talk about what those questions actually mean, like the actual legal impact of those questions and how you can answer them without escalating the situation or hurting your case. Now, remember, these questions are designed with one specific hidden goal, and that is to build a case against you using your own words. Do you know why I pulled you over? We've all heard this question. It's one of the most common and typically one of the first questions they ask you after your license and registration. And it sounds harmless, right? It's the beginning of a conversation. But this question is not harmless. This question is not part of a conversation. It is bait. You see, the officer wants you to articulate something you were doing wrong, because that is the legal standard that the officer needs in order to pull you over. You see, an officer needs a reasonable, articulable suspicion that a violation has occurred. That is the legal threshold that the officer must meet in order to stop your car. And he's asking you to give it to him, right? He's asking you to fill in that blank. And if you do it, you've basically justified this traffic stop against you. And in fact, you may even form the basis for a new charge, right? If you say, oh, I was just looking at my cell phone, but he pulled you over for speeding, you just walked yourself into a new charge. Why would you ever help the officer make the case against you? Here, let me give you an example. You say, I was speeding just a little, or I'm in a hurry, or I'm sorry, officer, I was just looking at my phone real quick for directions. You've just confessed to a traffic violation before they've ever even accused you of it. You have no real idea why they stopped you in the first place. When you do this, this is absolute gold for the police officer, because now they don't need to prove anything against you. You've already admitted it. You've already justified the basis for this traffic stop. Now, legally, under the Fifth Amendment, you do not need to answer this question. You are not in custody yet, and so you don't actually have to be read your Miranda rights. But let's be clear, anything you say here at this point can and will be used against you. That is especially true because every police department we deal with these days has you recorded at this point at the traffic stop. You are being audio and visually recorded, so absolutely anything you say can and will be used against you in court. So what's the right move? Don't guess, don't admit, just stay calm and polite. Try this. I'm not sure, officer. Would you please tell me? Right? Now, don't have a negative tone or don't be combative with your tone. The goal here is simply to protect yourself, not to escalate things or be combative. You're not going to win that fight. Instead, stay neutral. But I know what your next question is. Everyone says, well, if I don't answer, don't I sort of look guilty? No, that's in your head. Get it out of your head. Because refusing to answer a question is not proof of guilt. Courts understand this. This is a fundamental constitutional right to stay silent. So staying silent is not an admission. It's an exercise of your constitutional right. Police officers know this. Judges know this. It's time that you know this as well. Where are you coming from tonight? This one sounds like small talk. It feels like small talk, but it's not. This question is all about context, you see. Because if you say, I just left, Dave's bar, or I was out at such and such restaurant, the officer can now connect it to alcohol. Similarly, if you say, I was just at my friend's house. By the way, that's an incredibly common answer. I hear that all the time on these body-worn videos that I watch. I was just at my friend's house. Every single time, that invites more questions. Right? That invites the officer to say, where are they located? How long were you there? Were you drinking? What were you doing there? That always invites more questions, and now you've just sort of gotten caught up in the web of questions. So this one you hear all the time, and just a side note on this, I think that officers have really conditioned the general public to answer this question because they ask this even when it's not a DUI investigation. Right? And even when you sort of have a very innocuous answer, like I was coming from work, right? And you got pulled over for speeding, there's no suspicion of DUI. They ask that and you're sort of just naturally answer. And anyone who's been pulled over a few times has sort of dealt with this. And so when it is a DUI investigation, they've already sort of preconditioned you to answer this. And I get it. It can be difficult to sort of break that habit, if you will, but it's incredibly important in this scenario because, again, you are not required to answer these questions in Illinois. Illinois law does require you to provide your license, your registration, your insurance, but beyond that, you do not have to offer any information that could be used to build the case against you. So here's a couple ways that you might want to respond. I've heard it suggested that you could say, I was out and about. That is incredibly sort of innocuous, right? That's a non-answer answer, right? Now, you're going to be pressed a little bit more, but that's one that is really hard for an officer to pin down. And it's true, you were out and about. So that's one way to answer it. The other way is the much more straightforward, officer, I am refusing to answer any further questions. Now, that I get it. You may view that as sort of an escalation, right? But that is another very solid way to answer that because it's on solid legal ground. That is on solid legal footing when you tell the officer that you will not be answering any further questions. But a myth or sort of a question I hear often around this situation is, can I just lie and say I was just coming from home, or I was just at work, or I'm going to the library, or whatever it is? The answer to that question is no. Lying can backfire bad, like perhaps even worse than telling the truth. Because if your car was seen on surveillance or nearby, or there was a call in, or the officer had been following you for a while and you didn't realize it, this is a bad look, right? If there's direct evidence that contradicts you, they know you're lying, and that dishonesty is going to lead to suspicion, and that dishonest answer, absolutely 100 out of 100 times, is going to be raised in court if this case ever goes to trial. I've watched probably thousands of hours of DUI arrests on video, and I can tell you that I've seen this question backfire so many times. Whether you were too truthful, right, by saying, oh yeah, I came from so-and-so bar, right, Shenanigans Tavern 20 minutes ago, or you were totally dishonest by saying, I just was coming from home right around the corner, and that's easily proved to be a lie. Either one of those scenarios got you into a whole heap of trouble, and it's going to lead to the officer having a legal basis for proceeding further with this DUI investigation. So don't guess, don't lie, don't confess. Just stick to the script, which I think probably the best answer is, I exercise my right to remain silent. Have you had anything to drink tonight? This is the big one. This is the question that is almost always asked in one form or another in a DUI investigation. It might sound like, have you been drinking? Or be honest with me, how many drinks have you had tonight? Right? Different versions of that. But the problem here with this question is that almost any answer hurts you, right? Any answer that is above 0 hurts you. So if you say just 1 beer, or even more commonly, I see people just say, I just had 2, that's not going to get you off. That's not going to let them, back up. That's going to make them lean in further. You just made an admission to consuming alcohol. I promise you that if you say even just 1 or even just 2, they are getting you out of that car to do standard field sobriety tests. Why? Because you've given them the legal justification to do so. And also they assume that everyone's going to underreport how much they drank, right? But even 1 drink gives them that probable cause to investigate further. It's an admission to consuming alcohol and getting behind the wheel. Think about it. So we know that admitting to consuming alcohol, any amount, is not the correct answer. So let's go through. What are our other options? Well, you can say no, right? And of course, if you didn't drink any alcohol, definitely say no. But what if you had, right? You had consumed alcohol, you basically lie and say that you don't. But if the officer smells alcohol or sees other signs of impairment, they're going to believe that you've lied and they're going to try to use that against you. Let me be clear. I think that's a better situation to be in than making the admission. Now, I'm not telling you to lie here, but I am telling you that scenario where you do not admit to consuming alcohol, the officer doesn't quite believe you, is a better situation than you admitting to consuming alcohol and the officer believing you. In fact, in a U.S. Supreme Court case called Berkemer versus McCarty, the United States Supreme Court ruled that these officers can ask you these questions before they've read you your Miranda rights. So yes, they can ask this and it can be used against you before you've ever been given your Miranda rights. So it's considered evidence, right? It is evidence against you even though you were not arrested yet. So how should you respond? What is a third option? Yes, I've consumed alcohol. Terrible answer. No, I've not consumed any alcohol. Much better answer, especially if it's true, but could have some pitfalls too. Another third option is to say, officer, I respectfully choose to remain silent. That is a third option. Again, let me be clear. I like the answer of no, and I like the answer of refusing to answer any further questions. Far better than I like the answer of yes, I've consumed alcohol tonight. But the next question you're going to have is, won't I lose my license in this scenario? No, the answer is no. Let's be very clear about how you lose your driver's license. Here in Illinois, you do not lose your license for refusing to do those roadside tests in a DUI alcohol-based investigation. You do not. You can refuse to answer those questions. You can refuse to do those standard field sobriety tests, and it will not affect your driver's license. The license suspension only applies when refusing to do that official test after you've been arrested, and we are not at that point yet. So refusing the official test does have consequences, right? Typically a 6-month or 12-month suspension for a first offense. But that's not what we're talking about here. We're just talking about the questions and your answers when you're sitting in that driver's seat still and the officer's at your window talking to you. Now I get it. If you say yes, the officer digs deeper. If you say no, but the officer doesn't believe you, he's going to dig deeper. And the third option of saying, officer, I respectfully refuse to answer any further questions, what do you think that's going to do? It's going to cause him to dig deeper. So what's the next question that's coming out of that officer's mouth? It's something to the effect of, are you willing to step out and do these tests to prove to me that you're not intoxicated? That is trick question number 4. And the officer's not always that nice. They may be a bit more aggressive here, right? They may not ask it as a question. They may tell you you need to start doing these standard field sobriety tests. But that in and of itself is a trick because these tests are not required here in the state of Illinois. So how do we handle this? Well, first and foremost, let's address this issue of proving to the officer that you're not intoxicated, proving to the officer that you are okay to drive. Well, you don't have to prove anything to the officer. The officer is the one who eventually will have to prove it against you, right? You are innocent until proven guilty in court, right? So you don't have to prove anything to this officer. What he's actually saying is, why don't you help me out by justifying my suspicions? And you should not do that. And the field sobriety tests are probably the key way, besides your own admissions, in sort of the obvious stuff like finding alcohol in the car. Those standard field sobriety tests are the main way that they are going to build this case against you. It's an officer checking your eyes. You don't know what your eyes are going to do. There can be eye problems. You can have, you can be working in a factory, smoky eyes. There are a million explanations for how your eyes may react. And this officer, definitely not medically trained here to check someone's eyes. So that's the first test. The second one is about walking a straight line. You're basically being asked to walk a tightrope outside, on uneven ground, in the cold, perhaps in high heels or bare feet. I've seen that many times. And to do some wacky tightrope tests that most people cannot do standing dead sober in their living room. But they want you to do it out there on the side of the road. And the third test is this one-leg stand where I see all the time people with foot, ankle, knee, hip, back injuries over the years and have a really hard time doing those tests. So there is no actual requirement that you do those tests here in Illinois. So get it out of your head that you need to prove something to this police officer. It's his job to prove this against you. And so you have every right in the world to simply refuse to do those tests. So now that you know that you do not have to do those standard field sobriety tests, you are not required. And you also know that, at least here in Illinois, there is no consequence. There is no suspension of your driver's license that comes from refusing standard field sobriety tests. It is up to you to decide if you want to do them or not. There are, on very rare occasions, people who do those standard field sobriety tests and, as they say, pass. Now, it's not really pass-fail, but pass, and the officer lets them get in their car and drive away. I would suggest to you that that is incredibly rare, especially if you've been actually consuming alcohol, right? If the officer smells it, if there's other signs, then this officer's not letting you get in that car and drive away. He's just not. And so in that scenario, I would suggest that since you can refuse it and there is no consequence for refusing it, you may be far better off refusing it rather than giving up evidence against yourself. So what do you say to the officers? So if you choose to refuse these tests, how do you do it in the right way? You do it in a calm, respectful, neutral way without sort of guessing or apologizing. You simply say, officer, I refuse to do these tests. I've seen people sort of blame it on something like an injury. I've seen people blame it on the advice of their lawyer. So if you do feel the need to sort of blame an outside third party or an outside thing rather than just your straight up refusal, I like the one of blaming your lawyer because it's true, right? Most DUI lawyers are at least going to counsel you on how this works. And they will tell you that, just like I am now, that you at least have the option to refuse that. And so blaming your lawyer is a pretty good one. Blaming injuries works too, except then it sort of opens the door for the officer to get into all these injuries. It's very unlikely that you have injuries that are affecting your eyes, affecting you to stand on one leg, affecting you to walk, right? So a good officer I've seen will break down exactly what those injuries and kind of get you to do it despite those injuries. And he'll say, oh, I'm going to take that into account, right? So I like the idea of if you're going to refuse and you want to blame someone, blame it on your lawyer. We're all okay with that. Remember, your job here is not to prove your innocence on the side of the road. It is to avoid giving them free evidence against you. So now the officer has a decision to make. Are they going to arrest you for DUI? Now, you have not given them extra evidence, hopefully, so that makes it more likely that they will let you go. However, if the officer believes that you're impaired or under the influence, they're not just going to let you get in the car and go, despite what you've said, right? And so in that scenario, the officer may make an arrest. And when they do, something changes in you. I've seen it time and time again over the years. When you are arrested and put in handcuffs, especially if it's your first time ever being in handcuffs, most people have a very large emotional reaction. And it's totally understandable, right? Your freedom of movement, your night has changed. You now are starting to sort of identify as somebody who is arrested for DUI and all the consequences that may flow from that. So it's highly emotionally charged. And the officers know this. So the officers are often going to circle back around to these questions and try to get a new answer because they know that you're in a different state of mind. They will often read you your Miranda rights. That's what they're supposed to do at this point in time. But you may not be paying attention to that, or you may quickly forget about that your answers here can and still will be used against you. You see, just because you were arrested doesn't mean that the investigation ends. It is still ongoing. The arrest is not the end point here. What happens in court is the end point. That's the conclusion. And an officer knows this, but you may not realize this. You may realize that, oh my gosh, my life has been turned upside down here because of the arrest, and you're forgetting about what's going to happen later in court. So the officer's going to circle back around, especially to that question of how much have you had to drink tonight? Because if you answer that question differently now, and you are far more likely to, because of your emotional state, if you answer it differently, the officer then can use that to justify everything up until that point. Sort of a retroactive, at least they're going to try, the prosecutor's going to try to make that sort of a retroactive justification for all the officer's actions. And they're going to use that against you. And that's pretty damn good evidence against you. And it's also proof that you were lying earlier, right? So be very wary of this. Be very careful of this. Officers I have seen will sometimes hammer on this over and over and over and over again, which worsens or degrades your emotional state even further. And they'll do that in order to try to get you to answer this question differently this time. So that is a major trick that is used by police officers even after the DUI arrest. So remember, if you're pulled over, you must provide your ID, your registration, and your insurance. But beyond that, you do not have to answer their questions, especially these questions that are designed to trap or trick you into giving evidence against yourself. In fact, the smartest move is often saying less, not more. And thankfully, the Constitution protects you from self-incrimination, but it's up to you to actually use that protection. See, you won't talk your way out of a DUI, but you absolutely can talk your way into one. So speaking of officers' tricks, did you know that there are more secrets or sort of insider knowledge that if you're not aware of them, it can take a routine traffic stop and land you in jail? So check out this next video where I break down 5 secrets that the cops don't want you to know.